The certified letter arrived on a Tuesday morning, thick and official, the kind that makes your stomach drop before you even open it. Marcus Chun, 42, a civil rights attorney who'd spent 15 years defending homeowners against predatory practices, stood in his kitchen staring at the document in disbelief. Notice of lien, $487,600. His hands trembled not from fear, but from the kind of cold rage that comes when you realize someone has made a catastrophic miscalculation. For 18 months, HOA President Linda Whitmore had been manufacturing violations, stacking fees, and threatening foreclosure over a garden fence that met every single code requirement. 18 months of certified letters, harassment, and legal threats over a fence that was completely, demonstrably legal. But Linda had finally crossed a line she didn't understand existed. Because what Linda didn't know, what she couldn't have known from her perch of small-time power, was that Marcus didn't just know property law. He'd written portions of the state's HOA reform legislation. And this $500,000 lien she just filed? It was about to become the most expensive mistake the Pinewood Estates HOA had ever made. Where are you from? Tell us in the comments below. And if you're loving this story, hit that like button and subscribe for more. Now, let's see exactly how this unfolded. This is a story in 3 parts. The violation that revealed corruption running deeper than anyone imagined. The confrontation where a vindictive HOA president discovered she targeted the one person who could dismantle her entire operation. And the resolution where justice didn't just arrive, it came with a court order and a liquidation notice. The first outline explores how a reasonable man endured 18 months of escalating harassment, watching a neighborhood tyrant abuse her position while the HOA board remained willfully blind. It reveals the breaking point where professional courtesy ended and legal expertise began, where Marcus stopped being a tired homeowner and became the attorney who'd been documenting every single violation of fiduciary duty, every falsified fine, every procedural abuse. The toll it took on his family, the sleepless nights reviewing bylaws. And the moment he realized Linda had just handed him the evidence he needed to take down the entire board. The second outline details the confrontation that shifted everything. The emergency HOA meeting Marcus demanded. The manila folder that made board members go pale. And the moment Linda realized the homeowner she'd been tormenting for a year and a half wasn't just going to fight back, he was going to win. It captures the power dynamic reversing in real time. The revelation of evidence that exposed systematic fraud. And the ultimatum that gave the HOA exactly one chance to make things right before the courthouse doors opened. The third outline reveals how the resolution unfolded in ways Linda never imagined possible. The court hearing where a judge reviewed 18 months of harassment and fraudulent liens. The discovery of HOA funds misused for personal expenses. And the consequences that rippled through Pinewood Estates like a legal earthquake. It explores the aftermath when the smoke cleared. What happened to Linda and the board members who enabled her. And how one attorney's refusal to be bullied transformed an entire community's relationship with HOA governance. Here's exactly how it happened. Marcus Chun had purchased the Pinewood Estates property in March 2022. Drawn by the mature oak trees and the half-acre lot that backed on the protected wetlands. At 42, with a thriving civil rights practice and 2 teenagers who needed space to breathe, the house felt like a sanctuary. His wife, Jennifer, a pediatric oncologist, loved the screen porch where she could decompress after hospital shifts. Their kids, Emma and David, claimed the finished basement within hours of moving in. The Chuns were exactly the kind of stable, professional family most HOAs would welcome without question. They paid dues on time, maintained their property meticulously, and kept to themselves. The trouble started that first spring when Marcus decided to replace the rotting back fence. He pulled the permits, consulted the county regulations, and reviewed the HOA covenant standard practice for an attorney who understood that details matter. The new fence was 6 feet tall, pressure-treated cedar with a natural finish, set back exactly 18 inches from the property line as required. It was beautiful, functional, and completely compliant with every regulation on the books. Marcus had even submitted the plans to the Architectural Review Committee 6 weeks in advance, receiving written approval without a single requested modification. 3 days after installation, Linda Whitmore appeared at his front door. She was 56, with the kind of rigid posture that suggested she'd never met a rule she didn't want to enforce twice. Her title as HOA president had been renewed for 7 consecutive terms, a detail Marcus would later recognize as the first warning sign. Linda informed him with barely concealed satisfaction that his fence violated the covenants. When Marcus produced the approval letter, she waved it away. The committee had made an error, she explained. The fence needed to be 4 feet tall, not 6. Marcus politely referenced Section 4.7 of the covenants, which explicitly permitted 6-foot privacy fences on properties backing conservation areas. Linda's smile thinned. She'd be in touch, she said, and left without another word. The first fine arrived 2 weeks later, $150 for an unauthorized structure. Marcus wrote a detailed response, attaching photos, permits, county codes, and the approval letter. The fine was rescinded. For 3 months, he thought the matter was settled. He was wrong. In August, another violation notice arrived, this time claiming the fence color violated the neutral palette requirement. Marcus provided documentation proving cedar's natural finish was specifically listed as approved. Another rescission. Then came violations for fence height measured incorrectly, for visual obstruction that didn't exist, for maintenance issues that were fabrications. Each time, Marcus responded with documentation. Each time, Linda eventually backed down. But the violations kept coming. By December, Marcus recognized the pattern. This wasn't about the fence. This was about control. Linda had decided his initial challenge to her authority required punishment, and she was systematically manufacturing violations to assert dominance. When Jennifer suggested they just take the fence down and rebuild to 4 feet, Marcus had to explain why that wasn't the solution. Capitulating to unlawful demands didn't end harassment, it encouraged it. Linda needed to be shown that her actions had consequences. But as an attorney, Marcus knew documentation was everything. So he started keeping meticulous records. Every violation notice, every response, every communication, time-stamped and filed. The harassment escalated through 2023. Violations for mailbox placement, for lawn height measured at dawn when grass was wet and appeared taller, for holiday decorations that were allegedly commercial in nature, a claim about Jennifer's modest wreath that was so absurd Marcus actually laughed. Other homeowners started mentioning similar experiences in hushed conversations at the neighborhood pool. Linda had a list of people she targeted over the years, a rotating cast of residents who committed the sin of questioning her authority. The HOA board for neighbors who'd served alongside. Linda for years rubber-stamped every decision she brought forward. They'd stopped asking questions long ago. Marcus tried the official channels first. He requested a hearing before the board to address the pattern of harassment. The hearing lasted 12 minutes. Linda dominated the conversation, presenting a narrative of a difficult homeowner who refused to cooperate with reasonable requests. The board nodded along. Marcus's documentation barely received a glance. The violations stood. All of them. When Marcus pointed out that the bylaws prohibited stacking fines for the same issue, Linda smiled sweetly and noted they weren't the same issue. They were multiple separate violations. The board meeting ended with a warning that continued non-compliance would result in escalating consequences. Marcus left that meeting understanding that negotiation was pointless. Linda had built a small empire in Pinewood Estates, and the board members were either complicit or too intimidated to challenge her. Fine. If they wanted to play legal hardball, Marcus would show them what that actually looked like. He stopped trying to reason with them and started preparing a case. Every violation notice went into a color-coded binder. Every response, every timeline, every procedural deviation from the HOA's own bylaws. He pulled the HOA as financial records publicly available under state law and began noticing irregularities. Consulting fees paid to a company owned by Linda's daughter. Management expenses that seemed inflated. His professional instincts were screaming that Linda's little empire was built on more than just power trips. And then, on that Tuesday morning in November, the lien notice arrived. $487,600. Linda had taken every manufactured violation from 18 months, applied maximum penalty fees, added interest at rates that exceeded state usury limits, tacked on collection costs, and filed a lien against his property for nearly $500,000. The notice stated the HOA would pursue foreclosure proceedings if the amount wasn't paid within 30 days. Marcus set the letter on his kitchen counter and called his office. He'd be taking the rest of the week off, he told his assistant. He had a case to build. If Linda wanted to fight, she was about to discover what fighting a civil rights attorney actually looked like. Marcus waited exactly 3 days before filing his response long enough to let Linda feel confident, sure enough to catch the HOA before they proceeded further. He hand-delivered a formal demand letter to every board member, to Linda, and to the HOA's management company. The letter was 12 pages of precisely cited violations of fiduciary duty, improper lien filing procedures, usury violations, and potential embezzlement. It referenced 80 months of documented harassment and attached a thumb drive containing every violation notice, every response, and a forensic analysis of the HOA's financial records that raised serious questions about where member dues had actually gone. The letter concluded with a simple ultimatum: rescind the fraudulent lien within 72 hours, or Marcus would file both civil and criminal complaints. He also demanded an emergency special meeting of the full HOA membership under the bylaws that permitted any homeowner to call such meetings with proper notice. The special meeting took place in the community clubhouse on a cold Saturday morning in early December. 73 homeowners showed up in unprecedented turnout. Linda sat at the head table with the 4 board members, her expression tight with barely controlled fury. Marcus stood at the podium with his manila folder and a calmness that came from absolute certainty. He didn't start with accusations. He started with a simple question. How many of you have received violation notices you believe were unjustified? 42 hands went up. Marcus let that visual sink in for a moment. Then he opened his folder. He walked the crowd through Linda's pattern of harassment, not just against him, but against dozens of residents over 7 years. He showed the timeline of manufactured violations. Then he moved to the finances. The HOA had collected approximately $240,000 annually in dues from the 120 homes in Pinewood Estates. Marcus displayed a chart showing where that money should have gone according to the budget and where it had actually gone. Consulting fees to Linda's daughter's LLC for community management services that duplicated the actual management company's work, $47,000 over 3 years. Landscaping contracts awarded to Linda's brother's company at rates 60% above market value, $83,000. Maintenance expenses that had no corresponding work orders or receipts, $34,000. The room went silent. Board member Richard Torres, who'd served for 4 years, stood up slowly. Linda, is this true? Linda's face flushed. She launched into a defensive explanation about competitive bidding and family businesses needing support, but her voice was shaking. Marcus didn't interrupt. He simply placed the next document on the projector, the $487,600 lien notice. He walked through how Linda had violated 8 separate provisions of state HOA law in filing it, how the fees had been manufactured, how the interest calculations were criminal usury. Then he revealed his final card. Linda filed this lien knowing it was fraudulent, Marcus said quietly. And she did it because I started asking questions about the finances. This wasn't about offense. This was about silencing someone who could expose what's been happening with your money. He turned to face her directly. You picked the wrong homeowner to bully. Linda tried to respond, but board member Sarah Kim cut her off. I move for Linda's immediate suspension as president pending a full forensic audit. The motion passed unanimously, with Linda abstaining. Within minutes, the board had voted to rescind Marcus's lien, to retain an independent auditor, and to place Linda on administrative leave. Linda stood, grabbed her purse, and walked out of the clubhouse without a word. But everyone in that room knew the fight wasn't over. It was just beginning. The forensic audit took 6 weeks. The auditor's report, delivered in late January, confirmed everything Marcus had documented and uncovered additional irregularities totaling $127,000 in questionable expenses over Linda's 7-year tenure. The HOA board voted to file a civil lawsuit against Linda for recovery of misappropriated funds and to report the findings to the district attorney's office. Marcus, meanwhile, filed his own lawsuit in circuit court, a federal civil rights claim under 42 U.S.C. Section 1983 for deprivation of property rights through abuse of governmental power, plus state claims for harassment, intentional infliction of emotional distress, and fraudulent lien filing. The court hearing on Marcus's motion for summary judgment took place on a February morning that felt like vindication crystallized into legal proceeding. Judge Catherine Morrison had a reputation for impatience with frivolous litigation and zero tolerance for HOA overreach. She'd reviewed Marcus's submission, a 47-page brief with 200 exhibits, documenting 18 months of harassment. Linda's attorney, clearly uncomfortable with his client's position, offered a weak defense about HOA discretionary authority. Judge Morrison cut him off mid-sentence. "Counselor, I've reviewed the record. Your client filed a $500,000 lien based on manufactured violations and fraudulent fee calculations. That's not discretionary authority. That's actionable fraud." She turned to Marcus. "Mr. Chun, what are you seeking?" Marcus stood. "Your Honor, I'm seeking declaratory relief that the lien was fraudulent, compensatory damages for 18 months of harassment, punitive damages to deter similar conduct, and attorney's fees. Additionally, I'm requesting the court order the HOA to implement new governance procedures to prevent future abuse." Judge Morrison nodded. "The lien is declared void and fraudulent. I'm awarding compensatory damages of $75,000, punitive damages of $150,000, and full attorney's fees. Additionally, I'm ordering the Pinewood Estates HOA to implement a governance oversight committee with independent community representation." She paused. "And I'm forwarding this record to the district attorney for potential criminal prosecution." But the most dramatic moment came when the judge addressed the HOA's finances. Based on the forensic audit submitted as evidence, she ordered the HOA to pursue full recovery against Linda Whitmore, including the authority to place liens against Linda's own property if necessary. The board had already voted to liquidate a portion of the reserve fund to cover immediate settlement costs and audit expenses. Linda's small empire, built on intimidation and financial manipulation, was being systematically dismantled by the very legal system she tried to weaponize against Marcus. Linda's husband filed for divorce 6 weeks after the judgment. The district attorney's office opened a criminal investigation into embezzlement and fraud. Linda eventually reached a settlement with the HOA, agreeing to repay $127,000, plus interest over 5 years, and accepting a permanent ban from serving in any HOA leadership role in the state. The 4 board members who'd enabled her all resigned. Sarah Kim became the new president and immediately implemented reforms, term limits, independent financial reviews, a homeowner bill of rights that required clear evidence and due process before any fine could be imposed. 3 months after the judgment, Marcus stood in his backyard on a warm evening in May, watching Emma and David throwing a football near the fence that had started everything. Jennifer joined him on the porch with 2 glasses of iced tea. "You think it was worth it?" she asked. 18 months of stress for a fence? Marcus smiled. It was never about the fence. It was about showing people that bullies lose when you refuse to be bullied. and that the law works when you know how to use it. In the end, Marcus had learned something he'd always taught his clients, but had never quite understood viscerally. Justice doesn't arrive magically. It arrives when someone who knows the system refuses to let abuse stand unchallenged. The Pinewood Estates HOA had been transformed from Linda's personal fiefdom into a community governed by actual rules, real accountability, and respect for homeowners' rights. And Marcus, standing in the evening light beside the fence that had sparked a revolution, felt something close to peace. Across the country in Boulder, Colorado, retired aerospace engineer Patricia Duval received a letter from her HOA demanding she remove the solar panels from her roof panels she'd installed with full permits and that were specifically protected under state renewable energy laws. The HOA president, Mark Chun, had cited aesthetic concerns and threatened a $10,000 fine. Patricia smiled, a tight expression that her former NASA colleagues would have recognized as dangerous. She opened her laptop and began drafting a response that referenced not just the State Solar Rights Act, but the Federal Solar Rights Act of 2023, the HOA's own Green Initiative language from 3 years prior, and the small detail that she'd served as an expert witness in 14 renewable energy disputes and had never lost. Mark was about to discover that threatening an engineer who designed satellite power systems was a special kind of foolish. But that's a story for another time.